out there who wants to know about litigating a partnership dispute, today we're going to try to provide the answers for you. So without further ado, I'm going to ask Mr. Pilley to please just tell the audience who you are and what you do and why you do it.
Hi everyone, I'm James Pilley. I'm an attorney. I've been an attorney for about 13 years, and I'm primarily a litigator, and I litigate all sorts of business disputes and real estate disputes. Yep, that's pretty much me.
Okay, so when we're talking about a partnership dispute, for those people out there who are in a partnership and they're thinking, that they may have a lawsuit, even before they go to an attorney, like what types of things should they gather for the attorney meeting to try to, let the attorney know what type of case they have?
Sure. Well, a background of the dispute would certainly be helpful, but if there's any kind of partnership agreement, operating agreement that sets forth the parties' understanding, that would certainly be helpful. Emails, contracts, if there's been anything that has been violated, and just anything that's going to help the attorney understand what the dispute's about and how it got to the place that it's at currently.
Okay. Now, there are a lot of people out there who, on certain occasions, they enter into agreements with family members, friends, and they believe because they are family members or friends that perhaps they don't need an agreement. What do you have to say to those people?
Well, even family members get into fights and disagreements. And the problem is that an agreement isn't just for fights and enforcing it against. It helps the parties at an early stage come to an understanding about the different questions that are going to be posed when they go into business together. And so it allows the parties to have a discussion early on, put down their understanding in an agreement so that they can reflect back on it later. Okay, and it lets you hash out a lot of the issues that are going to come later and solve the questions and resolve the questions that you may have before they become problems. Okay, and so even if you later have a dispute, people's memories aren't always 100%. There's been lots of studies about, how people remember things, and some people remember things intentionally in the wrong way, and some people honestly remember things differently. But if you think about these things before they become problems and you write them down, you can always direct a family member back to this document and say, hey, we discussed that it's at an early stage, and we made this decision. Remember, we talked about it, and we thought it was so important that we wrote it down. And then hopefully you can head off a dispute before it festers and becomes something that you have to, file a lawsuit against over. But just because you're family members and just because you're getting along now doesn't mean that you won't have a dispute later. If everybody in the world did exactly what they were supposed to, you would never have any need for agreements. But the reality of it is we're all human. We get into disputes. We have misunderstandings. We have misrememberings of things that happened in the past. And if you take the time early on to sit down and write out and ask the hard questions early on, hopefully you can avoid those problems later on. And if you do have those problems later on, hopefully it's something that you've already discussed and wrote down how you're going to handle it. And that's what an agreement helps with.
That's a good point. So just in addition to that, or to clarify, there are a lot of people out there who, maybe with a sister or a brother or even a friend, they agree to go into business together and they start working, for this company, and just based on a verbal agreement, and then they have a falling out. Under those circumstances, what can they do under those circumstances? Where they just had a verbal agreement, they've already invested in the company, maybe they've been working in the company for a few years or even a few months, and all of a sudden they have a falling out. Where do they stand at that point?
Well, you still have a partnership agreement. You've gone into business together. Hopefully, you can try to resolve the issue amongst yourselves. If you need an attorney to help you write letters or something like that, to try to informally resolve the problem, that's always best. I think any attorney will tell you that litigation should be something of last resort, and you should try to figure out a way to resolve it amongst yourselves, because litigation is a lose-lose situation. When you go into litigation, it should be your last resort. So hopefully, the parties haven't crossed a line where they've got their backs up against the wall, and the only thing you're going to do is go to court to resolve the situation. Hopefully, you can get a neutral. There's different types of what we call alternative dispute resolution. You don't need a lawsuit to go possibly to mediation and have a neutral evaluate your case and help you try to resolve it so you can get back to business. But if the dispute is such that this is a partnership ending dispute, if you can't resolve it informally, if you can't resolve it amongst yourselves, there certainly is the litigation route.
So are you saying that, and you did talk about the importance of having an agreement earlier, are you also a proponent of maybe including a clause in the agreement that mandates mediation, because you were referring to the importance of mediation?
Certainly, and I think that you should even have more than that, possibly agreements to have meetings, try to resolve things before even mediation, maybe having impasse procedures in your agreement, monthly meetings, dispute resolutions internally, some other mechanism besides actually having to go to a neutral before you get to that point to try to resolve things prior to the point where you got involved third parties. But yes, certainly mediation. Some people might have an arbitration clause in there. Arbitration, you're starting to get very close to litigation, and a lot of times the cost involved with arbitration might be just as much as full-on litigation, and the rules of evidence are relaxed in arbitration. So I'm more of a proponent for trying to put things in your agreement that allow you to resolve disputes informally before you get even to those more formal alternative dispute resolution products like mediation and arbitration.
Okay, so a lot of our audience members are concerned about financing, and you did allude to the fact that you strongly recommend that they try to resolve the case before having to even get into court. Let's look at the situation where they've tried to resolve it informally, it didn't work out, and now they've gone to an attorney. Is there something they can do, and I think you made reference to some letter or something, is there something they can do prior to having to pay for the expense of an entire lawsuit? What can they do to try to nip it in the bud before it gets going?
Certainly. I'm always a proponent of communication, open channels of communication, and sometimes a well-worded demand letter. I hate to use the word demand letter, but a letter explaining your position, explaining how the problem can be resolved and what can be resolved in a formal way, in a well-thought-out way, instead of screaming at each other. An attorney, if you go to an attorney, they can help you put down your best arguments in a well-intentioned way that you can send to the other side, well thought out, and hopefully the other side can digest that letter and see the wisdom of whatever you're asserting, and hopefully you can resolve your case, your matter that way.
All right. Now, suppose they get into a situation where they have a dispute, they've tried to work it out, they've sent a demand letter, and unfortunately they're at an impasse and they haven't been able to work things out. What's the next step? I know the next step may be litigation, but I guess as an attorney, what is the goal of initiating litigation? Is it automatically trying to get to the end, or is there something else in mind that you're contemplating when you initiate a lawsuit?
No. I'm not going to give out the statistic, but most cases settle before trial, and certainly there are many ways to win a lawsuit. It doesn't always have to be getting to trial. If you're at the point where only a lawsuit is going to cause the other members of your partnership to come to terms, certainly we already talked about mediation. That's one of the programs that I imagine any court's going to encourage you to engage in. But when you file a lawsuit, now you take it out of the hands of the individual partners who may have been fighting for so long that they build up walls. And now you have, hopefully, clear-minded, impartial attorneys who are certainly going to, assert your best foot, but hopefully can come together and talk reasonably and try to explore solutions to resolve your problem without going all the way to trial. And there may be things that have to be, what I'll say, discovered through discovery. That's kind of a technical term. It's one of the things that we use, one of the tools in any litigation that allows us to get answers to questions that we may have. And that may be something that needs to happen between the partners before they can resolve their dispute. They may need to find out all the facts behind the particular dispute before they can come together. But hopefully, a good litigator, I think, is primarily a problem solver. And all along the way, they should be trying to find a way to resolve the issue.
All right. And again, we're always concerned about the finances of our clients. So trying to resolve a case before litigation, the lawsuit starts, one of the parties is served with the lawsuit. Is there a chance at that point that the case could settle?
At every stage of litigation, there's a chance that the case could settle. So certainly, I always tell my clients that every step of litigation is a cost-benefit analysis. So you have to determine whether paying more to fight on is worth finding a resolution at that particular point. Now, certainly something has to be on the table, and both parties have to be interested in settling. But at every step of litigation, you should be looking for ways to resolve a case.
So for people who have a dispute over a business and litigation starts, and they want to dissolve the corporation, is the court mandated to dissolve the corporation? Is one of the parties able to potentially buy the other party out? What are the dynamics, and does the company have to end with certainty?
No. So, yeah, there's two types of dissolution. There's involuntary dissolution, that may be bankruptcy or court order, but there's certainly voluntary dissolution where the parties come together. One side could agree to buy out or give some other kind of compensation, and the partnership could live on with the remaining partners, or an individual can take it over as a sole proprietorship. That's certainly something that can happen. You can be creative at that juncture. There is no one way to resolve that dispute. There are many ways in which you can come to an agreement and go your separate ways. If it comes to the point that you realize that the partnership's no longer working for both the partners, and that separation has to happen, you can be creative, certainly.
Okay. And you have a situation where two people or even more are involved in the business, and one of them is demanding that the other one pay a certain amount of money, and the other one claims that, well, you're asking for too much. Mm-hmm. What does the system have in place to try to figure out what that company is worth? What happens if there's a dispute with regard to the value of the business?
Well, there's a number of different ways to value a business. There's the market valuation, there's EBITDA. There's a number of different ways that you can value a business. What's the value of the assets? So I would suggest that if you're at the point where you're looking at buyout, possibly you have an appraiser perform, a couple of these different evaluation tools, and you try to close the gap between the partners, open up a dialogue, have a negotiation, try to figure out, what price will get this resolved, and you can look at, the different types of analyzing how a small business is valued, and try to come to some kind of agreement on what the reasonable valuation is. Small businesses are very hard to value. They're not like publicly corporations where there's an open market that sets the value of the shares. It's it's not an impartial process, and there's a number of different ways to value a business.
All right. So we have a partnership. They're at a lawsuit. Each side has its own version of the events. The litigation started. The complaint is served. What happens next? What's the next phase of litigation, and what is the goal of that particular phase?
Okay, so if I remember right, you said the complaint has been served.
The answer has been filed.
Okay, answered and filed. Okay, so now I kind of touched on this earlier on. We're in the discovery stage. This is the fact-finding stage where we have specific tools that are given to us by the law, the rules of procedure that allow us to answer questions that we may have, to ask the other side under oath, to admit things, to answer questions that we may have, to produce documents that prove up or disprove our case. That a way that we can go to trial well prepared, all right, to prove our case or disprove our case. It's the time for gathering evidence.
I see. And then, just for people who may not know, you're in a lawsuit. That's an opportunity to tell your story, right? And the telling of your story usually occurs during the discovery phase. Can you describe for the audience what a deposition is, where it takes place, what the dynamics is of those?
Sure, and I didn't touch on that. Another aspect of discovery is certainly depositions or subpoenas, deposition subpoenas of third parties that aren't involved in the case. And so what that is where you come in and you sit down, and the other side, the other attorney usually, will ask you questions under oath in front of a court reporter or stenographer who will take down your answers and type out a transcript. Sometimes it's taken with video evidence, but it is I would actually fight against the idea that it's a time for you to tell your story, depending on who you are. If you're the deponent, it's a time to answer their questions as honestly as possible, but as directly as possible, and usually not to elaborate. I certainly counsel my clients that it's not their time to tell their story, but it is a way for you to meet the other side, the defendant or a party in the case, and ask your questions, get a read of them of how they're going to behave at trial, certainly, and try to get to the heart of the matter of the dispute. One of the components of a deposition or a subpoena depo is that a lot of times you ask them to bring documents, and so you'll ask them questions about particular documents that are germane to the case.
Okay, so what do you have to say to the person out there who says, and we get a lot of these people, I'm going to do the deposition myself, and maybe I'll get an attorney later on at trial, but I can't afford an attorney right now, and I think I can, tell my story and defend my case or prosecute my case through my deposition well. I don't need help. What do you have to say to that person?
Well, I think I already touched on it. It's not a time for you to make your case. It's a time to be very straightforward with your answers, honest, but very short and curt in your response. If it's a yes or no question, answer yes or no, don't elaborate. And so a lot of times without the coaching of an attorney, you're going to go in there and you're going to start, telling your story. And you may reveal facts that the other side wasn't aware of. And so you're going to give them opportunities to go down rabbit holes that they may not have known about prior to that. And you can find yourself very quickly in trouble. And laying out your story in a deposition may not be what your later attorney that you hire at trial wanted. That wasn't the direction that your attorney wanted to take the case. And you may have already backed yourself into a corner by stating certain things on the record that you're not going to be able to come off of or redirect when you get to trial. So you may put your trial attorney in a position where he's unable to put your best defense forward because you've already said things that have backed yourself into a corner at your deposition.
All right. So you're advocating for a client. You're in discovery. And as an attorney, and you did touch upon the deposition, what other tools do you have in your arsenal? Like if you want to try to find out things in the case or discover theories from the other side, what types of things can you do as an attorney in the case?
Beyond discovery, or are you
different,
talking about
different components of discovery?
Okay. So the different components of discovery we kind of talked about. Okay. There are document requests, which we talked about. You can ask them for documents that prove or disprove their case, or prove or disprove your case. You could also ask them to admit certain facts, and those are called requests for admissions. And then there are interrogatories where you ask specific questions and ask them to provide facts to support their answer to your question. And then we talked about depositions and subpoenas. If there's third parties that aren't part of the case, there is a mechanism to get documents and answers from third parties that aren't involved in the case if they're holding evidence that is important to your case. And those are done through subpoenas for documents, or subpoenas for deposition. And there's even subpoenas for written questions that you can use to elicit information from third parties.
All right. And then as a mechanism in the case, we started the case. Unfortunately, they had no choice. They had to go and start a lawsuit. They participated in discovery. Is there a goal with respect to discovery? Are you looking to get to another point when you can settle, and where would that point be?
Certainly. The point that I'm trying to achieve in discovery is I'm trying to prove up my case. I'm trying to gain the facts and the documents necessary for me to go to trial and win. And if I get those, depending on what side of the case I'm on, whether I'm a defendant or a plaintiff, if I'm a plaintiff, if I get enough information that proves my case to a certain certainty, I think at that point I can then make demands on the other side that have more weight, and hopefully they'll come to the table and try to settle with me because they see the strength of my case. On the other side, if I'm trying to defend a case, I found enough documents or evidence, written evidence, answers to my question that disproves the plaintiff's case in such a manner that they should be willing to come to the table and try to resolve the case, or they risk going to trial and losing.
Okay. So what do you say to the client who says, this is costing me a lot of money. You've shown me, attorney, that I have a great case and the other side doesn't have a case. Do I have to go all the way to trial? Is there something you could do, a motion or something you can do to put the case before the judge to see if the judge can dispose of the case without them having to go to trial?
Certainly. So there is what we call a motion for summary judgment, which is essentially a trial on paper. It says the facts aren't in dispute, so judge, you can make a ruling as an issue of law. There's no need to have a trial where a jury has to decide what the facts are. The facts aren't in dispute, so judge, please issue a ruling based on the facts that have already been developed in this case. And that's a way to get the case resolved. There's a motion for summary judgment and there's a motion for summary adjudication. A little more disfavored by judges, but that allows you to pare down the issues that are going to trial.
I see. Great. So let's see. Let's talk about the client they've gone through discovery. Maybe they had an opportunity to file a motion for summary judgment or not, and now they're at the next phase. What is the next phase? Usually the courts have something in place where they try to get the parties to come to an agreement, and we're going to get into that. But what is that? What's the nature of that?
Mandatory settlement conference.
Yeah, or mediation is the next step.
Or mediation or mandatory.
Yeah, same thing.
So the court system is impacted. Most people are aware of that. The court has a vested interest in you trying to resolve your case. There's a lot of mechanisms that they put in place to try to get the parties to resolve their case before going to trial. As we said at the beginning of this, trial should be a last resort. And so there are court-sponsored mediation programs, there are mandatory settlement conferences where there are retired judge or settlement conference judges inside the court that will help facilitate settlements between parties. There's also private mediation where the parties agree to go before a particular mediator who's probably esteemed in a particular field. So there are a lot of ways, but if the court system tried every case that came in front of it, it would fall apart. It doesn't have the bandwidth to try every case that comes into its courtroom. So the court very much encourages the parties having dialogues and trying to resolve the case before trial.
Okay, so what do we say to the client who says, you've had my case for 6 months, I haven't gotten into trial, you're dragging my case out. Can you just talk about typically, how long it takes, even if you want to get to trial, in California, what are we looking at as far as a timetable procedurally to get a client's case to trial, even if you are an aggressive attorney and even if you are trying to push that case to trial?
Well, like we said before, the courts are very impacted. They have impacted calendars. So typically it's 2 to 3 years from inception that you'll be able to get into court. Excuse me. That's usually when they're setting out trial dates. And even though you get that trial date, a lot of courts, especially in big cities where they have a lot of cases, you come into trial that day, they don't have a courtroom for you, and they'll put you on the wheel or they'll table you out to the first available court date that they have. So even an attorney that is aggressively litigating a case, even if you wanted to try that case within 6 months, it's probably not feasible just with the court's calendar. And you probably want to take more time to really develop your case and do a thorough discovery. And I don't know if 6 months is enough time to do that. Generally, courts are setting what we call conferences, excuse me. They're setting case management conferences out 6 months from the day you file the lawsuit. And at that point, they're asking the parties where they're at in the status of litigation, and they're asking them if they're ready to go to trial and when they'd be prepared to go to trial.
Okay. So before we get into the nuts and bolts of mediation in our next segment, what we didn't talk about is the client who says, I want to file a lawsuit. You know, I live in maybe San Diego and my business partner lives in Sacramento. I want you to file a lawsuit here. What goes into play when you're talking about suing in a certain locale?
Okay, well, if you have a partnership agreement, a well-drafted one anyways, it probably should say where the court that you're going to be litigating in. Certainly the choice of law, if you're both in California, would be probably California law, but then we get into what we call venue, what would be the appropriate venue, and that's the benefit of having a well-drafted partnership agreement, is that you can set forth where any dispute would take place. But assuming you don't have something like that, a lot of things are going to come into play. It's a balancing act of different factors. Probably where you do most of your business, where most of your assets are. If you have a storefront where you do where most of your we're talking small businesses here, so where you do most of your business is probably going to be venue that's most appropriate for the case. If we're talking about larger businesses, and more formal businesses, there are other procedures that deal with that, where their residency is, where their primary operations is. Those are factors into determining where the venue is proper.